Over the past 4 years, we've seen the rise of a very bitter political environment in this country, marked by equally bitter legal and constitutional struggles. This is uniquely dangerous for Americans because, unlike almost any other country, the one thing that binds us together as a nation is the law, especially the Constitution and our respect for it. This makes our courts, our judges, and our judicial system crucial to the kind of country we'll have in the future. With us to talk about that today is Gerard Bradley, professor of law at the University of Notre Dame, where he teaches legal ethics and constitutional law. He also directs with John Finnis, Notre Dame's Natural Law Institute, and co-edits the American Journal of Jurisprudence, an international forum for legal philosophy. A former prosecutor and the author of too many scholarly and general audience articles to list, Professor Bradley has been a visiting fellow at Stanford University's Hoover Institution and a senior fellow at the Witherspoon Institute based in Princeton, New Jersey. He also served for many years as the president of the Fellowship of Catholic Scholars, and over the decades has been a mentor and friend to literally scores of men and women doing the lay apostolic work of the gospel. Jerry, thanks for taking the time to speak with us today.
I'm happy to do it, Frank.
It's good to see you.
Yeah,
we don't get to see each other enough. Jerry, let's get right into it with some basic stuff. You and I have talked about this in the past, but most people understand good laws are important to a free society, but the question remains what constitutes a good law, and specifically, is it good because it's useful? I mean, the issue of utility, moral content, popular support. What makes a law good?
Well, finally, it's the moral content, and most specifically, it's whether the law serves the genuine common good of a society. And we tend to think of common good as if the phrase is common goods, plural. And we tend to think of the common good as if it's comprised mostly of highways and school buildings and police forces and the army and a currency. And that's all true enough, but those are all secondary parts, or you might even call it the material elements of the common good. Fundamentally, the common good of our society is the genuine good of the people in it. And the authority of law is finally rooted in, and the authority of lawmakers to, you might say, anticipate or expect our obedience to laws, is that they serve the common good. But I would add that I wouldn't say the situation is very complicated, but it is worth noting that although that's fundamentally what makes law good, there are many other features that can make laws bad, or you can make even good laws not especially helpful. So it's easy to see that a law which is written so poorly that you can hardly understand what it's saying is not a good law, entirely apart from moral content. Or if they should pass a law but then forget to publish it so that we're not aware of it, that obviously is a bad law. But nonetheless, it's nothing to do with moral content. Now, there are times when the morally good law is pretty much the same as the useful, practically effective law. If you're putting in a sewer system, the main thing is that it actually carries away the sewage, and there's not much more to it. So there are a lot of features, you might say, that contribute to perfect law or extremely helpful and good law, but there's one factor that's required, and that has to do with the way it serves the common good.
You know, the philosopher George Parkin Grant made the point, is a Canadian philosopher, and he made the point that the United States is the only modern industrial society that has no history before the age of progress, before the age of the Enlightenment. And how does that affect things? I mean, well, I mean, in a sense, the United States is an abstraction. It was created out of nothing. Now, if that's the case, is it true that misusing the law in this country has an amplified effect on the negative tone of a culture? I mean, is my point that law is especially important, is that really true in this country?
Well, I think it is true. I don't have the precise numerical citation in front of me, but I can refer your listeners to an article by Francis Cardinal George, which article was titled Law and the Culture of Marriage, and it was published actually in the American Journal of Jurisprudence in about 2002. And in the course of that article, Cardinal George made the point that America is a society, he's speaking of 2002, in which law is the one thing that really binds us together, that we're not so much bound by tradition, ethnicity, race, or even to a large extent now by language. We have a history, but history is disputable, you might say, or there are different versions of our history. And I think that is true, that America is a country, because of its polyglot composition and its foundation, you might say, in a set of political ideals, where the law plays a uniquely important role. So when the law is morally corrupted, as in some important ways it is now, or has been weaponized in other ways, which I think has happened, then it becomes a very crippling element, or has a crippling effect on the society. I would add only, Fran, that it is quite true, as many people, including yourself, just mentioned, that there's a way in which it's quite right to say America was founded, if not upon abstractions, but upon propositions or self-evident truths. And I think that is true. One thing that I would add, though, is I think perhaps we are discovering now, have discovered recently, and I think it'll become even more apparent as we go forward, that there's a way in which a society that's living only by the laws is going to live on fumes. Once not a particular ethnic narrative withers away, but when you have a sort of addled moral foundations of law, and where the true meaning of the common good, namely the genuine good of persons, has been corrupted or is disputed, or according to some prevailing political theory, is to be put aside by the government, that the law should be neutral about the good. But I do think that if not a particular ethnic narrative or even a particular historical master narrative is essential to a community's well-being, but if you live by law alone, I think you live dangerously. And I do think we're in some danger of having squandered or exhausted the moral capital which had been built up over generations, so that the moral foundations of law, the true common good, is addled, corrupted, not disappearing, but put out of mind all too often. So that we're in a very difficult situation where, to put it very plainly, legal mistakes are going to be highly consequential in our society.
Mm-hmm. Jerry, what is the difference? People talk about positive law. What's the difference between positive law and when Christians and Jews talk about natural law? I mean, and is natural law a purely religious concept, or does it predate Christianity and main religions that we know?
Well, I do think it's supra-religious. That is to say, it predates Christianity. There were natural lawyers in ancient Rome and ancient Greece. I do think that the onset of Christianity, indeed the history or prehistory of Christianity and Judaism, is an important element of adds important clarifications and force to the natural law. But the natural law is independent of religions. Believers, unbelievers, believers of different sorts have converged upon what amount to the propositions of the Ten Commandments. And positive law, not only for the philosophers and for the practicing lawyer, but I think a definition of it that's perfectly fine and helpful to anyone is to think of it as all the laws which are not true and binding by virtue of their truth, apart from human action, but rather positive law is law that's enacted or posited by people. It's that which is produced by human lawmakers. The civil law of the United States is positive law. The Constitution is positive law. I think the canon law of the Catholic Church is positive law, meaning texts or stipulations, propositions actually written down. That's the way Thomas Aquinas used the term. He, I think, was probably the first, at least thinker that I'm familiar with, and maybe in fact the first thinker in human history, to very securely and clearly distinguish the natural law, that is, propositions about right and wrong, which hold good apart from what anybody thinks of them or whether anybody's enacted them. Thomas distinguished the natural law, what's true about right and wrong, from posited law of various sorts. And it's a very useful distinction. Now, it's not to say that they occupy entirely separate spheres. And fundamentally, as we mentioned earlier, I talked about earlier, what makes for good positive law is finally rooted in natural law. But there is a certain healthy and substantial autonomy, you might say, to the positive law.
Mm-hmm.
So that when I teach my students, as I did just up until 2 weeks ago, the constitutional law of civil liberties, a lot of it has to do with what the courts or the Constitution actually says. And even I taught Roe versus Wade about a month ago, and there's a way in which Roe versus Wade is the law. And you have to study Roe versus Wade to see what the law is. Now, it's mostly a matter of unjust law in that case. But again, there is a positivity, you might say, and a certain, and I want to say certain validity to the written law, which you can grasp and should take account of, apart from whether the law is just or unjust. But make no mistake about it, the injustice of the law is a very important reality that anybody should take into account.
Yeah, when I read as a non-specialist, I read the Declaration of Independence, and that seems to have a very obvious natural law context or content to it. I mean, it has an idea, an anthropology, an idea of what a human being is that as a Christian I resonate with. But that seems to be absent from a lot of the judicial, I mean, like the Supreme Court decision making that's been going on over the last 50 years. Why is that, and how did it happen?
Well, it's a good question, and I suppose it's a question that's more than we can answer in this short time. But I think the leading part of any explanation and I would describe what's happened as the court has very largely abandoned the moral foundations of law across broad swaths of the law. It's not the truth that the Supreme Court, liberal conservative justices, think that there's no moral reality. Liberals, conservatives alike believe in justice. They don't always have the right idea of justice. Sometimes it's skewered, but they believe in justice that's not reducible just to what's written down somewhere. So there is morality on the Supreme Court. What has been lost, I would even say repudiated by the Supreme Court, and this is mostly, we're talking here about what's called liberal judicial activism. There's been a repudiation of sexual morality, the morality that pertains to family life, the meaning of marriage, when life begins. So again, it's not to say that these are just matters about sex. It's not even just a matter of talking about what we might call colloquially culture war issues, but that is on the right track. That is to say that there is a big, substantial part of morality, a part of morality that affects the well-being of people, family, religion, sexual morality, which has been abandoned by the Supreme Court and replaced, not exactly, I would say, by a substitute morality, where there's really, you might say, a disagreement or argument between people with different moral visions. It's rather that the common morality, the tradition, the morality of the Ten Commandments, biblical morality, you might say, that informed American law of family and sex and religion forever, was abandoned in favor of something very egocentric. It's what's substituted for morality. You could call it an ethic of self-actualization, or you could describe it as a kind of therapeutic approach to the law, at least in these areas. So that what's substituted for moral reality is something about enabling persons to come to some kind of serene contentment with their own choices. And that so far described nothing to do with what's truly right and wrong, but a more psychologized understanding of making sense of one's own choices and experiences. And that's the objective of the law.
Jerry, in the context of what you just said, how do you describe or help people understand the mystery clause in the Planned Parenthood versus Casey 1992 Supreme Court case, and how does that fit into the kind of cultural struggles that we're going through today?
Well, I think it's central to those cultural struggles, and you're referring to a passage in the 1992 case that affirmed Roe versus Wade. So it was an abortion case. I don't know if you'd say ironically, but interestingly enough, in an opinion authored by 3 Republican appointees to the Supreme Court, and they would be Justices O'Connor, Kennedy, and Souter. Those justices here are writing in terms or communicating a message that would be an anthem to any liberal activist on the court. They said that the court's holdings going back about a generation and family, marriage, education, child rearing, etc., sex, really should be best understood, and this is the mystery passage, as if they were all realizing a meaning of liberty which the court described as each person's right to define his own concept of existence, of meaning, of the universe, and the mystery of human life. Now that is you might say, the moral counterpart to what I mentioned or described a few minutes ago as a kind of therapeutic jurisprudence. That is to say, when the focal point of well-being in this jurisprudence is each individual's kind of psychological wholeness or feeling of contentment. That's a kind of psychological side or picture in a diptych, where the other side of it is more strictly speaking moral. And the mystery passage is about liberty. It describes itself as describing or about the heart of our constitutional liberty, this kind of self-invention. Now that's false as a matter of text and history and tradition, but there it is in 1992. But morally speaking, it's the counterpart to a therapeutic jurisprudence, because what it's really saying is the moral value of all these choices about private, what they would call private matters, family, sex, education, children, etc. The value has nothing really to do with whether these choices that people make correspond or actualize the truth, correspond to the truth, or actualize the moral truth, or are morally right or wrong. All of the value, according to this way of thinking and looking at the world, resides in what would be called, in this point of view, a kind of authenticity. The value is that these are choices and decisions that are, this is the hypothesis, really mine and express the real me and have to do with who I really am and bring into being my deepest identity. So that the value is that it's mine, not that it's true or corresponds to your truth or my truth. So that's what I mean if I've succeeded in describing it. On the moral side, you would say it's a kind of subjectivism about morals. What's morally good is what's good for me as I see what's good for me. And the psychological side is that the result of that will be a kind of satisfaction with one's choices as being one's own.
Jerry, on this issue of therapeutic jurisprudence, you did a really interesting article just recently in First Things with the Johns Hopkins scholar Paul McHugh, and you focused in a particular way on Bostock, the June 2020 Supreme Court decision that I believe the majority opinion was written by Justice Gorsuch. Could you explain what Bostock said and the reasoning that Gorsuch used, because Gorsuch is typically perceived as a conservative judge?
Sure. Now, Bostock was the name in the Supreme Court reports for a group of 3 cases that came together. They're all employment discrimination cases. As a matter of fact, they have to do with the civil rights statute. They're not themselves constitutional law cases. Although I would add that the reasoning, which is quite mistaken in Bostock, is likely to find its way into constitutional reasoning in short order, but they are statutory cases. Gorsuch did write the opinion for the Supreme Court. His opinion was joined by Chief Justice Roberts. So there are 2 Republican appointees and men who are at least ordinarily described as conservatives, who are in the majority. And the holding in Bostock came in 2 parts because it was a group of 3 cases. But the short of it is that the Civil Rights Act, which prohibits employment discrimination, and the term in the law is because of sex. That term, because of sex, is in the statute, and up until about June of 2020 was all but universally considered to refer to discrimination on the basis of one person being male as opposed to someone being female or vice versa. But the Supreme Court held that because of sex also included discrimination on the basis of or for the fact that someone is same-sex attracted, which interestingly, I just note in passing, Justice Gorsuch consistently described as homosexuality, a somewhat quaint term. He did not use the term gay or lesbian, by the way, but nonetheless, it was same-sex attraction and also transgender identity. So going forward, at least since June of 2020, employers who are covered by Title VII, which is this law I'm talking about, and that's, well, almost any employer in the United States except for very, very small mom and pop shops, they are prohibited now from discriminating in employment decisions on the basis of someone being transgender or, for example, in a same-sex marriage. So that's the decision. I focused in the article in First Things that I did with Dr. Paul McHugh, mostly on the transgender side of this decision. And the transgender side of the decision is flawed as a matter of legal reasoning. And that's sufficient to criticize it in, I suppose you could say, a conclusive way. But the opinion is also infected or suffused or honeycombed with mistakes and is corrupted by the influence of this therapeutic jurisprudence. So to put it plainly, just for an opening statement, Justice Gorsuch didn't say what some courts and other lawmakers are saying about transgender people, which is that they actually are people born in the wrong body. Some people who decide cases of this sort, whether it involves high school students and access to bathrooms or locker rooms, some judges and other lawmakers, when they make law, will say the little boy is really a little girl because the little boy thinks he is a little girl. Gorsuch did not say that, but he was seduced by, and I think even made uncritical, and even in a certain respect, and I say this in a limited respect, made lazy and indifferent to moral reality by the effects of a culture which has already decided, at least in the parts of the culture that came to surface in this case, whether you're a man or a woman, whether you're a boy or you're a girl, isn't really all that important. What matters is what's in your mind. And what matters is the person you imagine yourself to be. So again, summarily, Justice Gorsuch did not make a metaphysical mistake and literally took the view that you are a girl if you think you're a girl. It's not that, but it's something that's almost as bad. It's whether you're a girl or a boy is not that important. What's important is what you think you are. And other people should treat you according to what you think you are.
Well, that seems like a recipe for solipsism and anarchy.
Absolutely. Well, it's certainly a recipe. It is, and I think it is solipsism. You know, the only relevant realities are those that are projected out of the person's mind. I think that is the mystery passage. And it won't end in anarchy, only because that there's and this has been true, I think, well, since the mystery passage was christened in 1992. There's a way in which that's, as you say, a recipe for anarchy. But I don't think we're going to see anarchy. And I think actually we see that, well, the COVID is an extraordinary situation, but I will use COVID, the pandemic, as an example of the following phenomenon, which I think is not limited to COVID, that at the same time, according to the construal of law and human well-being that I've been describing, the mystery passage in Bostock, I would say, in that view, so-called private life is like the carnival. You kind of invent yourself and masquerade and impersonate. And whatever you present as during carnival is kind of the reality for the duration of carnival. Private life is carnival, but in public life, it's very much conformity. And COVID is an example of that. Now, it's not so much about carnival and private, but to put it very plainly, liberal governors and liberal legislators, and I dare say a liberal president that is Joseph Biden, are not going to hesitate to crack the whip and make people conform to what
Yeah.
they honestly believe are the requirements of public order and public health. So, although there's a way in which the mystery passage sets a trajectory, or they're the compass bearings for anarchy, that's not actually what happens, not what has happened. Um, there's almost a draconian counter action or reaction in the public sphere, where because private life has no real connection morally with public well-being. So to put that differently, and unlike in the case of the founding and the American tradition up until probably the 1960s, where the idea basically was private virtue is an essential element of public well-being. We don't think that. We think private life is carnival, and that public order is supplied because it's necessary, but it's supplied by a very heavy-handed
Right.
law. So there's a yin and the yang, I suppose, a yin and the yang or some other image that could be used to describe it as a action reaction, but you have a centrifugal force in private life spinning around and threatening to spin out of control, where everybody's self-realization is a matter of what's going on in their mind, and there's no common moral truth guiding those choices. It's to each his own, and every man or woman for himself or herself. So there's a reaction in the public sphere,
Right.
to impose, you might say, with an iron hand, order upon this carnivalesque, burlesque of private life.
Yeah,
Those go together.
it seems that personal disorder naturally produces a public repression. I mean, because something has to hold everything together.
Yes, I agree. That's a good way to put it.
And it's bizarre to see these liberal Democratic governors acting in precisely the way you're describing.
I think it is ironic, but I think only superficially ironic. I mean, this is not the occasion, nor am I probably the person to best describe, how it is that deep in the bowels of contemporary liberalism. Now, I'm not talking about all aspects of liberalism or all meanings of liberalism. There are ways in which I consider myself a liberal, but contemporary philosophical liberalism of the sort that finds expression in the mystery passage. I do think that in the bowels of that way of looking at human well-being and social order, you can find a kind of suppressed but very real pressure for conformity, and in a certain kind of authoritarianism when it comes to state action.
Yeah.
So I do think that that's true, but I think we'll see this probably even more. So I'll just give you one example. If the meaning, nature, and value of the family is no longer in a given culture supplied by morality and religion and tradition and culture, but family rather becomes the composition and decomposition and then recomposition of atomistic individuals at the spousal level, and then children and stepchildren, etc., or manufactured children. You can see almost readily that, boy, without tradition, culture, religion, and morality, how are we going to keep any of this kind of in line so that going forward we have at least this much order? We have children who have identified at least two parents who are legally recognized to be in charge of raising those kids. Now, these could be parents who are faltering, but they are at least the parent. But in this world, there's obviously going to be a great need for legal regulation, that each one, you might say, is an independent contractor, moving from relationship to relationship, creating children in and out of wedlock, within or apart from sexual activity. So what is going to order and keep on track something like family life? Well, it is going to be law. And you can multiply that example into other areas, whether it has to do with wider aspects of family life or even sexual relations generally. It's pretty clear in our culture, leave aside marriage and the family for the moment, that we're at a crisis point, I think, with sexual relationships, insofar as norms, moral norms, etiquette, traditions, do's and don'ts of sexual activity have all withered away. So again, sexually speaking, if you're over the age of reason, and maybe sometimes if you're not, uh, you're a free agent sexually. I think in our culture, we're holding this together, you might say, by a term called consent. So that if people consent, they can do what they want. But I think we're discovering that we're overloading consent and straining it to a breaking point, and discovering that consent can't bear the weight that we have assigned to it. So I think there's actually now developing a reaction to overloading consent. And we're going to see, in fact, in a way, a certain increase in regulation of sexual activity, whether it's in the workplace or within other relationships, professional relationships, expanding notions of sexual harassment, so that, just for what it's worth, even in the absence of sexual morality, and even where we hypothesize independent contractors seeking and obtaining sexual pleasure, I think we're going to see an explosion in law.
Mm-hmm. Jerry, you talked about the need for a new conservative legal philosophy or legal activism. What are the differences between the way the cultural left and right look at the Constitution, and how does that fit in with what you're talking about in terms of a new conservative legal philosophy?
Well, I do think that there is a difference between liberal activism and conservative restraint. I think liberal activism, going back to the Warren Court era, which means really starting in the 1960s and coming forward pretty much to the present day, liberals tend to see in the Constitution their moral ideals, whatever they happen to be at the moment. Now those moral ideals would be caught up in something about identity politics and making room for the equal respect for everyone in our society, and making room for everyone to live out their own imagined identity with self-esteem and drawing on respect from other people. But that's a moral construction, and it's morally idealistic, I said. Now, conservatives very much, or characteristically, I should say, reject that view of the Constitution. They think of the Constitution in markedly different terms as having, and I don't mean this to be itself a criticism. I have a criticism of conservative constitutionalism, and I'll get to that in a minute. But conservatives, partly in reaction to liberal idealism, have thought of the Constitution probably since the mid 70s, but really more the mid 80s, when originalism came into conscious being. But conservatives have tended to think that the Constitution has much lower moral horizons, that it's more of a legal document which does not authorize judges to implement moral ideals or moral visions, so that the document is much more, according to conservatives, a legal document which lawyers applying the traditional methods of legal reasoning can supply the meaning of the Constitution. So you have the setup between liberal activism, which might be, for our purposes, better described as liberal idealism, and conservative restraint, which might be described as not so much lack of idealism, but a kind of morally lowered horizons, lower temperature to the Constitution, morally speaking. Now, my criticism is this, that in truth, I maintain, in truth, the Constitution has less to do with moral ideals than liberals think and act, but it has more to do with moral truth than conservatives tend to recognize or allow. So that, and it's not, I don't say that out of some desire to reach a middle ground or a compromised position. My own judgment is that the Constitution of the United States, according to its original understanding and the tradition of its interpretation, does at key strategic points rely upon, call for, and need moral truths for its proper interpretation. Now, I'll just give you the example that most readily comes to mind, and probably is the most important one in the marketplace of ideas now. It has to do with abortion. Now, liberals characteristically found abortion in the Constitution for whatever reasons you think you can discover in Roe versus Wade. The conservative criticism of Roe versus Wade has never been that the unborn have a right to life in the Constitution and that abortion is effectively outlawed by the Constitution. The conservative alternative has always been the Constitution is silent about abortion, neither requires abortion on demand nor prohibits it. The conservative position on abortion has been the Constitution is silent, states are free to do as they wish. If South Dakota wants no abortions, and they're free to have, practically speaking, none. If California wants abortion on demand, they're free to do that. I think both of those positions are wrong. I think when the 14th Amendment uses the word person and uses it in a legal proposition, as it does, that the states must respect persons and may never deny any person the equal protection of the laws, I think that that's a reference to the truth about persons, that persons, for purposes of interpreting the Equal Protection Clause, is the same thing as asking who are really persons. So that's just the leading example. There are others of where the meaning of the Constitution, I maintain, depends upon the truth of the matter, in a way that liberals deny because they're much more interested in abortion, but in a way that conservatives deny because they think the Constitution, not only by and large, but almost entirely, can be interpreted by judges and others without resort to moral truth.
Mm-hmm. Jerry, three questions that, well, one question that really has three parts to it to conclude here. What do you see happening over the next 20 years in terms of constitutional developments, legal developments? And in the light of that, what gives you hope? I mean, you're teaching at a Catholic university with a really terrific law school. I mean, you're really pretty extraordinary scholar from a Catholic perspective on these issues. I mean, for Napa Institute people who are primarily ordinary, intelligent folks who want to make a difference in the culture, I mean, what gives you hope in that context? And what can we do? I mean, what can ordinary Catholics do to try to assist people like you, assist law schools like the one you teach at, and be a good cultivating seed in the general culture? It's a big question, but you've got a brain that'll answer it.
Well, I won't deny that charge, but I won't affirm it either. But I will take a crack at answering the question. I think there are grounds to be sober about the immediate future, not just because of the incoming Biden administration, which I'm sure will do many good things, but I do fear there will be some very unfortunate decisions made, probably even early in President Biden's term, undoing some of the executive actions and administrative actions that during the Trump administration, people working for the president, and I suppose with the president's approval, were able to put in place vis-a-vis religious liberty and life. I do fear that they'll be overturned or reversed very early in the Biden administration. But so in the short term, I wouldn't say I lack hope, but I think I do have hope, but I think it's founded in a somewhat longer view. I think time is on the side of, well, if not the angels, at least on the side of some of the reforms that I've mentioned. I will focus only on the thing I was talking about just a few minutes ago, which is a new kind of constitutional conservatism, one that is properly open to and reliant upon moral truth. I think time is on our side there. I do think the Bostock decision from this past summer in June opened the eyes of quite a few people, maybe many people, to the shortcomings of what's usually called the conservative legal movement. Now, let me stress, the conservative legal movement is far preferable to the liberal legal movement. And the conservative legal movement is just fine for the most part. But it has, as I've described briefly, even in this conversation, a glaring deficiency when it comes to constitutional interpretation. And I do think, although Bostock's not a constitutional case, its comments about transgender and same-sex attraction are easily transportable to constitutional cases. And
Oh.
frankly, I think they will find their way, especially about transgender matters, into constitutional cases. But I do think that for that reason and others, I think there'll be a reckoning on the part of, we'll call them constitutional conservatives, but I would say more specifically, social conservatives who have allied themselves, I think, with open eyes and eager hopes with the conservative legal movement, will see that it's time to demand, they won't call for rejection, far from it, but will demand a substantial amendment of the thinking of constitutional conservatives.
Mm-hmm.
So that, as I say, at key strategic points, that constitutional conservatism, when it comes to, to interpreting the Constitution in courts, will be open to moral truth. I think that there's a fuse that's lit in Bostock, and the dissatisfaction that many felt with Bostock, and I'll just use words that I saw in the commentary, and these would be commentaries by social conservatives disappointed in the reasoning of the court and the outcome of Bostock. They would describe it as a soulless positivism, a kind of legal reasoning without moral compass. I'm not taking over these descriptions, but they're on the right track.
Yeah.
That deficiency, I think, is now all but exposed or on view to many, and there'll be a demand for reform. And I think in the longer run, there's room for optimism. There are an enormous number of younger, certainly compared to me and you, Fran, middle-aged judges that are put in the court by the Trump administration. I don't, in this particular regard, I don't know anything more about what Amy Barrett will do on the Supreme Court than perhaps you or your listeners do. She's been my colleague here for 18 years, but what I'm about to say is not based on any insider knowledge, but just upon her public record. But I think Amy Barrett, Justice Barrett, Justice Alito, Justice Thomas are surely up and ready, I think, for a consideration of this kind of reform. I'm not so sure about Brett Kavanaugh and the Chief Justice. We'll see. But their lower courts are full of people, I think, who are not necessarily in agreement with what I'm saying today, but are full of social conservatives who will, if they do not already, feel the sting of Bostock and feel the deficiency that's manifested in Bostock, where a moral deformation has insinuated itself into the technical legal reasoning in Bostock and produced results that are simply unappealing and frankly unacceptable.
Jerry, one final question very quickly that you unintentionally raised by some of the comments you've made. What are the consequences of expanding the number of judges? I mean, there's a lot of pressure from so-called progressives to expand the number of judges, and that just seems to be an overtly kind of nakedly political move in a way that could be destructive.
I agree completely. I realize that there's room to argue about how politicized constitutional law has become and how politicized the appointment process for the Supreme Court has become. That's a conversation worth having. But to expand the court to 10, 11, 12 justices is a quantum leap forward in politicizing the work of the court, which could only have, if it had any good effect from the progressive point of view, could be short-lived. It would so undermine the legitimacy of what the court does that the intermediate term effect, and surely the long-term effect, would be to undermine the authority of the court with consequences that I don't even think we could possibly predict at this point.
Yeah. Jerry, thank you so much for your time. It's a delight seeing you and talking to you again. And the people who see this are really going to be inspired by the things that you've said. I'm very, very grateful. And the Napa Institute is as well. So God bless you and your family, and we'll talk soon.